I'd like for you all to imagine a situation. This popular grocery store in town just had a big sale. It's packed, everyone's fighting for a parking spot outside. And this girl and her friend are leaving this grocery store's big sale and walking out into traffic. Now, as this girl and her friend are walking out, this girl is texting on her phone. Now, when they're walking into traffic, and her friend warns her and says, "Hey, pay attention, look at where you're going." The girl keeps on texting on her phone. Moments later, they're still walking out, and a car honks at her. But this girl doesn't even look up from her phone. She's still texting. When all of a sudden, she gets hit by a car. Now I ask all of you this. Would you hold the grocery store liable for what happened? That is no different than why we're here today. The plaintiff in this case, Bobby Daly, like the girl walking out of that grocery store, was also not paying attention. She was on her phone playing this chasing game. And like the girl walking out of that grocery store, she also received 3 different warnings. And she ignored all of them. The employee of the ice cream parlor the plaintiff was at warned her when she told her to leave at closing time. The plaintiff stayed. The plaintiff's friend warned her when she told her people were coming, they didn't look, they were coming to play the game, and they should get going. The plaintiff stayed. And then the person that attacked her later that night gave her a warning. She stayed. The plaintiff received 3 warnings and ignored all of them. We are here today because of the choices the plaintiff made. Now, all of this happened at Scooter's Ice Cream Parlor. And Scooter's is the hometown ice cream parlor. For a long time, it was the only ice cream parlor here in Steelton. Now, the owner of Scooter's, Tracy Simon, saw an opportunity. There were no ice cream shops in Steelton, so he opened one up. Then, the height of popularity of the chasing game in 2015, he decided what a great idea to have people come to Scooter's and play this chasing game while it's open. The plaintiff was one of those people who came to play the chasing game at Scooter's. And she was there playing the game for almost 3 hours. You'll hear today that the plaintiff was told by the employee when the store was closing at 10 p.m. to leave. And you also have a chance to hear that she did not leave. And you'll hear that the plaintiff's friends told her when they were out on the public sidewalk playing this game that maybe they should head out, people were coming. And again, when the assailant warned her, she received these 3 warnings. The plaintiff was trespassing on June 6, 2015. And because of that, Scooter's is not responsible for the incident that occurred that night. And we're going to prove that to you with 3 major arguments. That first one, the plaintiff was asked to leave. Number 2, that scooters had adequate security. And number 3, that the plaintiff was not paying attention. To my first point, that the plaintiff was asked to leave. You'll have a chance today to hear from the employee that was working that night at Scooters, Ms. Christy Vladanova. Now, Ms. Christy Vladanova is not here today because she has returned back to her home country of Russia. But prior to today's trial, she took a deposition. And today you'll have a chance to hear the transcript of that deposition. You will hear that Scooters closed at 10 p.m. You will also hear that Ms. Vladanova told the plaintiff to leave at 10 p.m. But the plaintiff went to the parking lot and then to the sidewalk. But Ms. Vladanova told the plaintiff to leave altogether. In fact, she told the plaintiff to leave not once, but 2 or 3 times that night. The plaintiff did not leave. And to my second point, that Scooters had adequate security. You'll have a chance today to hear from Mr. Tracy Simon, the owner of Scooters himself. And Mr. Simon will talk to you about a couple of things. He will talk to you about the security measures he's taken in the running of his business. He'll tell you that he installed cameras inside of his shop, as well as 2 cameras outside of his shop in the parking lot. He'll also explain to you that he installed 6 lights outside in the parking lot, which you can see right here. Now, the plaintiffs mentioned they have an expert witness, and we will have one as well. Our expert witness is Ms. Quinn Noonan. Ms. Noonan is a 10-year FBI veteran, and she now specializes in security. Ms. Noonan's job entails going to businesses and telling them whether the security they have in place is adequate. Ms. Noonan will talk to you about 2 things: cameras and lights. Ms. Noonan will talk about the cameras that Scooters had installed. And she will explain to you that cameras serve a purpose, and that purpose is a deterrent effect, meaning that when criminals see cameras, they are deterred from committing the criminal activity. In other words, they see a camera outside of a business, and in fear of being recorded and therefore caught, they are less likely or altogether not going to commit the crime. Ms. Noonan will also tell you that 2 cameras that Scooters had installed outside of the shop in the parking lot were adequate for a business like Scooters. Ms. Noonan will also talk to you about the lighting of Scooters, and she'll explain to you that lighting also serves a similar deterrent effect. And she'll tell you as well that the lighting that Scooters had outside in its parking lot was adequate for a business like Scooters. Now, Ms. Danielle will also tell you that just because a business suffers a criminal activity like this doesn't mean the measures they had in place were inadequate. After all, banks have armed guards, and they still get robbed. You'll also have a chance to see the police report that was prepared on June 6, 2015. And that report indicates that the lighting at Scooters was adequate. And to my third point, that the plaintiff was not paying attention. you've heard, the plaintiff will be sitting before you today. And we expect that when he takes his stand, he will admit some things to you. We expect he'll admit that he was told to leave Scooters at 10 p.m. We also expect he'll admit that his friends warned him that people were coming. They didn't look they're coming for the game, and they should get going. He'll also admit that he heard his assailant say something to him. And the language that assailant used was enough to put him on notice that maybe he should get out of there. Now, the plaintiff was at Scooters playing this chasing game for almost 3 hours, during which she was attacked. I also expect the plaintiff will admit to you that that night, everyone at Scooters, as well as the friends that were there with her, all managed to get away. We're not here to argue that what happens to the plaintiff is not terrible. What we are here to argue is that Scooters is not responsible for what happened. Ladies and gentlemen, no one was forcing the plaintiff to be on that public sidewalk at 10:45 p.m. at night. In fact, from everything you'll hear today in trial, it seems that everything was indicating to her that she should not have been there at all. But she chose to be there. And when given multiple warnings to leave, she ignored each and every one of those warnings. Because of all of this, I ask that you find the plaintiff responsible for her own actions. And because of that, you must not find Scooters liable. I'd like to talk to you about what caused you to go to Scooters Ice Cream Parlor on June 6, 2015.
Okay.
On June 6th, you went to your friend's baseball game.
Brother's baseball game.
After that, you went to get some ice cream.
Yes.
You chose to go to Scooters for that ice cream.
Yep.
While you were there, you purchased an ice cream.
I did.
And after you finished your ice cream cone, you stayed at Scooters.
Yeah, we all stayed. We're still playing Chase Them.
And you would arrive at Scooters around 8 p.m.
Yes,
correct?
8 p.m.
At some point, you were asked to leave, correct?
Yeah, we were asked, or an employee told us that they were closing, I think, so we went out to the parking lot.
And this was at 10 p.m.?
Yes.
You were asked to leave because the employee told you the store was closing.
Uh-huh.
I'd like to talk to you about where you went after you were told to leave Scooters.
Mm-hmm.
When you left Scooters, you went to the parking lot?
Yes.
Correct? Your Honor, permission to approach the witness?
You may.
Ms. Daly, I am handing you a diagram of Scooters and the surrounding area as it was on June 6, 2015. Your Honor, this document is believed as authentic, and we are offering what's been pre-marked as Stack 58 as trial exhibit number 2, I believe. 3. Sorry.
Any objection?
No objection, Your Honor.
All right, trial exhibit 3.
Wish to retrieve the document, Your Honor. Thank you. Your Honor, this time I would like to ask that the law to aid in witness's testimony.
Okay.
Your Honor, permission to reposition myself?
Sure.
Ms. Daly, can you speak all right?
Yes.
You said at 10 p.m. you were asked to leave Scooters, correct?
Yeah, we went outside at 10 p.m.
So you were inside of Scooters.
Yes.
And at 10 p.m. you went out into the parking lot,
Yeah,
correct?
a big group of us went outside to the parking lot.
Now you're in the parking lot. And I want to talk about what was in the parking lot. So you can see there's lights in the parking lot.
There were
correct?
there. Yep.
Okay, so there's 6 lights in the parking lot. You can see them right here marked by these L's.
Mm-hmm.
There were also cameras in that parking lot. There's 2 cameras, correct? Marked by these C's.
Yeah, I guess so.
Now, you're playing the chasing game in the parking lot, and at some point, you were asked to leave the parking lot, correct?
We were told to go to the sidewalk.
So you went from the parking lot to the sidewalk, correct?
Yes.
Yes, just walk
As
as
we were told to do, yes.
This is all the sidewalk, correct?
Yeah.
So you could have stood right here?
She
correct?
didn't specify where to go on the sidewalk. She just said go to the
Correct, you
sidewalk.
could have stood right here,
We
correct?
could have, yes.
You could have stood right here?
Sure,
correct?
but we didn't.
All these areas are well lit. You just stand right here with this X's, is that right?
That's where we stood, yeah.
And you marked this X yourself?
I did, I believe.
Now, you're standing where this X is, and you said the lights, lighting wasn't that great there, correct?
Well, it wasn't in front of the parking lot, but there was still light. It wasn't like I put myself in complete
You
darkness.
said the lighting on that sidewalk wasn't that great, the lights weren't working, correct?
Are you talking about the parking lot lights?
Where you're standing right here on the sidewalk, where you
Yes.
marked X, so the lights weren't working that night, correct?
The street lights didn't come on.
Okay, and those street lights belong to the town of Steelton, correct?
I guess so, I wouldn't know.
Objection, Your Honor. Lack of personal knowledge. Move to strike.
Well, she can testify if she knows.
Well, I don't know.
But you didn't choose to sue the town of Steelton, did you?
No, I didn't. I was on Scooter's property.
I want to talk to you about the moment before you were attacked, Ms. Daly. At 10:45 p.m., you were standing on the sidewalk, correct?
Still on the sidewalk, yes.
Okay. Now, this is your first time at Scooters?
Yes.
So that sidewalk isn't outside of your home?
No.
That sidewalk isn't a sidewalk in your neighborhood?
Objection, relevance, Your Honor.
Counsel?
Your Honor, assuming the rest presence of the jury, this line of questioning is simply just to further provide background. That's her first time at Scooters.
If you provide background that it's her first time in scooters?
Yes, that she was not familiar with the surrounding area.
Okay. All right. Your response?
Your Honor, assuming we're outside the presence of the jury, this fact has already been elicited from this witness that it was, in fact, her first time in scooters. To go any further down this line of questioning is duplicative as far as not relevant here at today's trial. She's already said that the sidewalk was in front of scooters, that it was her first time there. We don't need to know if it was right in front of her house. If that was the case, then it wouldn't have been her first time on the sidewalk.
Overruled.
Ms. Daly, you're standing outside on that sidewalk, and your friend said something to you, correct?
Yes.
Your friend indicated to you that people were coming, correct?
Yeah, he said that, but I didn't have any time to react.
This is why you're looking at your phone, is that right?
I couldn't tell you exactly what I was doing at that moment.
And you thought people were coming to the game, is that right?
I did because we had been at a chase place all day with a lot of people playing the game.
But your friend Rudy indicated to you that he did not think they were coming to the game.
That was what he thought, but I did think, I thought that was who was coming.
And moments later, you also heard someone else make a comment to you, is that right?
I did hear someone make a statement, but I had no time to react because I was instantly hit in the head.
You heard someone say to you, told you we could find these video game nerds here, easy pickings,
Yes.
is that right?
Yep.
And you're looking at your phone at this point?
I couldn't tell you exactly what I was doing, but I can tell you that as soon as I heard those words, I was hit in the back of the head, and I have no memory of what happened next.
Ms. Daly, you can't tell us what your assailant looked like that night?
No, because I was attacked from behind and I couldn't see him.
So you can't tell us if your assailant had brown hair?
No.
You can't tell us if your assailant had brown eyes?
I didn't have any chance to look at him. I was hit immediately.
And you couldn't see any of these because you were on your phone, is that right?
I don't know exactly where I was looking at the moment.
No further questions, Your Honor.
Redirect?
Yes, Your Honor.
Good afternoon, Ms. Summerstein.
Good afternoon.
In preparation for today, you prepared an opinion,
Yes, I did.
and to prepare that opinion, you did an informative report.
Yes, I did.
And in that report, one of your opinions was that the plaintiff was not a trespasser.
Yes, I believe that's correct.
And you based that opinion on the fact that the plaintiff was not asked to leave the night of June 6th.
Yes, and I believe it also said in the police report that the police did not charge her with trespassing, so that had to do with what I wrote in my report as well.
Okay, and you know that Scooters closed at 10 o'clock p.m. that night?
Yes, I'm aware of that.
Your Honor, permission to read a stipulation to the jury?
You may.
Specifically, it is stipulation number 1. On Saturday, June 6, 2015, defendant's business was open from the hours of 12 o'clock p.m. until 10 o'clock p.m. Ms. Summerstein, you were formerly an officer yourself.
Yes, that's correct.
You were a patrol officer for a period of time,
Yes, for 4 years in the Steelton Police Force.
and then you were in the homicide task force.
Yes, that's correct.
And in your capacity as an officer, you had the opportunity to interview witnesses for various crimes, correct?
Yes, that's part of the duties of an officer.
You interviewed victims of various crimes,
Yes, that's correct.
and as an officer, you had to weigh the credibility of those statements, correct?
To a certain extent.
You, in preparation for today, you reviewed the depositions in this case.
That's correct.
You specifically reviewed the plaintiff's deposition.
Yes, I did.
You were present today in the courtroom when the plaintiff testified.
Yes, I was.
You also reviewed the deposition of Ms. Filatonova,
Yes, I reviewed Ms. Filatinova's deposition.
and she was the employee working on June 6, 2015.
That's correct. She was the only one working.
You reviewed Ms. Filatonova's deposition in its entirety, correct?
That's correct.
And in her deposition, she stated that she asked the plaintiff to leave 2 or 3 times.
Yes, that's correct.
Yet, in your opinion, you stated that the plaintiff was not a trespasser.
Yes, that's correct.
Ms. Summerstein, now I'd like to talk to you about the security measures Scooter's Ice Cream Parlor had in place. Can you see that well, Ms. Summerstein?
Yes, I can.
I'd like to first discuss the lights with you.
Sure.
You'd agree with me that there's 6 lights here?
6 lights in the parking lot, yes.
Yes, and they're all marked by the letter L.
Yes,
And in your preparation for today, you reviewed the police report, correct?
that's correct.
You're on permission to approach the witness?
Sure.
Ms. Summerstein, I'm handing you what has been marked as Exhibit 1. It's the police report from the incident on June 6, 2015. I'd like to turn your attention to the description of the scene. Your Honor, before I continue, permission for my partner to distribute copies of the police report to the jury so they may follow along?
This is what's already been into evidence as Exhibit 1, right?
Yes,
Yeah.
sir.
Mhm.
Ms. Summerstein, again, I'd like to direct your attention to the description of the scene at the bottom of this police report. The police report stated that the officers arrived to a well-lit area. Is that correct?
Sure.
And that the parking lot, as you agreed, was appropriately illuminated.
Yes, the parking lot was well illuminated.
Police report also indicated that the sidewalk area and the property itself had ambient light. Is that correct?
That is what the police said. I'm not sure if that would be my opinion, but that's what this says.
Your Honor, permission to retrieve the document from the witness?
May.
Ms. Summerstein, I'd now like to talk to you about the cameras on Scooter's property. You know that there were, cameras inside the property,
Yes.
and there were also the 2 cameras outside right here, correct?
2 non-working cameras facing the parking lot. That's correct.
But they were still outside, correct?
That's correct.
And you know that cameras serve as a deterrent to many crimes.
Yes, cameras can be a deterrent to crimes if they're visible.
So visibility is important, is that right?
Yes, that's very important. Necessary for it to be a deterrent.
Now, again, you stated that you reviewed Ms. Filatinova's deposition in its entirety,
Yes.
and you know that she indicated that the plaintiff was standing right here when he was attacked.
I believe she indicated that he started to walk into that direction, not that she was standing there.
Ms. Summerstein, were you in the courtroom today when Ms. Filatinova's deposition was read?
Yes.
And you saw my partner, Ms. Fornes, come up here and comply by marking this?
Yes.
So Ms. Filatonova indicated that this is where she saw the plaintiff standing.
I thought that she indicated that that is where she saw the plaintiff heading, not where the plaintiff was standing.
Okay. Now, Ms. Summerstein, I'd like to talk to you about the plaintiff's conduct on the night of June 6, 2015. Now, you were a security officer, correct?
Yes, at the guard corp.
And you obviously, as a police officer, you're familiar with security issues.
Yes, definitely.
And you know that individuals have a responsibility for themselves sometimes. Is that right?
Individuals have a responsibility for themselves. I guess you could say that.
You know, again, you were present today in the courtroom when the plaintiff testified.
Yes, I was.
The plaintiff indicated that she was with some friends the night of June 6th.
Yes.
And you know from your review of the record that her friend suggested that they should leave.
I believe that was something that the friend said, yes.
But the plaintiff did not leave at that point.
I don't think the plaintiff had the opportunity to leave.
And then the assailant made a comment.
Yes,
Correct.
right before he smashed her over the head.
But once she heard that comment, she did not leave. Is that right?
She passed out
Yeah. And that's because she couldn't leave because she was unable to.
because she was hit over the head, yes. She was assaulted.
No further questions, Ron.
Good afternoon. Please say your name for the jury and spell your last name.
Yeah, my name's Tracy Scooter Simon. Last name spelled S-I-M-O-N.
Mr. Simon, is that a nickname, Scooter?
Scooter is my lifelong nickname. Yep.
How'd you get that nickname?
So when I was a small child, when most children start to crawl, this guy was scooting right on his butt across the floor. The nickname stuck ever since, and been called Scooters ever since.
Is that how you named your ice cream parlor after your nickname?
Exactly, Scooter's Ice Cream Parlor. Yep.
I'd like to now talk to you about your relationship to Scooter's Ice Cream Parlor.
All right.
How are you related to Scooter's Ice Cream Parlor?
I'm the sole owner and creator.
Where is Scooter's located?
Right here in good old Steel.
When did you open up Scooter's?
Approximately 5 years ago, maybe a little longer.
Do you own any other businesses?
No, this is my first and only business venture.
So why open up an ice cream parlor?
Well, there really wasn't one in that part of town, and it was a really up-and-coming neighborhood, and I saw a market, and I jumped on it, and it was something I always kind of wanted to do and get out of the old band, and that's what I did, and it's still open today.
I'd like to now talk to you about the measures you take in running your small business.
Yeah.
Can you tell very briefly what measures, if any, you take in terms of security for your business?
Yeah, I take several measures. Specifically, I have cameras installed inside and outside of my property. I have lights, and then I call service people anytime there's any issues with any of those things for them to come and fix them.
Now, you mentioned you installed cameras and lights. I want to talk about each of these measures more in
Okay.
depth. Just to briefly go over those cameras, where are those located?
So we have cameras on the inside, and there's also 2 cameras affixed to the western wall of the building, if you will, on the outside, facing my parking lot.
Now, you also mentioned lights. Where are those lights located?
There's 6 sets of them in the parking lot, kind of like evenly spaced.
I'd like to talk to you about the game the plaintiff was playing that night on June 6, 2015.
Yes.
Are you familiar with this game?
Yeah, I'm familiar with it. Yep.
Can you tell the jury what your understanding of this game is?
Yeah. So Chase 'em is a mobile phone game. You download the app, and you essentially move around using your GPS to catch these Chase 'em monsters.
Was Scooters associated with this chasing game on
little.
June 6?
Somewhat.
Can you explain some more about what you mean by somewhat?
So the game designates different places in any town, city, state, wherever, that are called chase places. The people that live there or have worked there don't get to have any impact on that. The game decides that certain places will be chase places, and in those chase places there can be rare monsters caught.
You mentioned these chase places. Did you advertise Scooters as a chase place?
Well, yeah. Once I discovered that the game designated my place of business as a chase place, I began to run ads. Yeah.
Now, the plaintiff mentioned she was playing this chasing game on your property at 10:45 p.m. that night. Was she allowed to be there at 10:45 p.m.?
No.
Why is that?
Well, we close at 10. And my employee told that Ms. Daly to leave.
Permission to retrieve what's been already admitted into evidence as exhibit number 2, Your Honor.
All right.
Mr. Simon, I am handing you what's been already admitted into evidence as exhibit number 2. This is the ad that was placed in your business on June 6, 2015.
This is it.
And Mr. Simon, on your ad, does it say anywhere what time Scooters closes?
Does not indicate any times, no.
So how would someone know that Scooters is closing at 10 p.m.?
My employees are trained to tell people to leave when 10 p.m. comes around.
Okay, and you mentioned you trained your employees. Can you elaborate some more on that?
Yeah, just simple stuff like closing the place down, like the basics that you need to know, like how to clean up, put things away, and to get people up and out of the ice cream parlor, so that they can do all those things.
You're under permission to retrieve the document from the witness.
Okay.
Thank you, Mr. Simon. Your Honor, at this time I'd like to make use of the demonstrative.
Okay.
Mr. Simon, would it aid your testimony at all to step down and make use of the demonstrative?
I think so.
Your Honor, may the witness step down?
You may.
Now, Mr. Simon, earlier you described some of the measures you take for the security of Scooters Ice Cream Parlor.
Yep.
You mentioned cameras and lights. I'm going to go over those more thoroughly with you.
Okay.
Can you describe to the jury where those cameras are located?
Yes, we have some cameras inside here, and then we have on the outside 1 and 2 cameras.
Now, what is the purpose of having these cameras located there, Mr. Simon?
To serve as a deterrent effect.
Can you describe to the jury what a deterrent effect means?
Well, if people think that they're being videotaped, they're less likely to commit crime, and that's why business owners will, or homeowners, property owners, will put cameras on the outside of the property. People think they're getting recorded, they're not going to want to be taped and get caught.
Makes sense. You also mentioned you installed some lighting in your parking lot, and that lighting is marked by these L's.
Correct.
Can you explain for the jury what the purpose of having 6 lights in your parking lot is?
To illuminate my lot so people can see where they're walking, where they're going. Same thing, a deterrent effect. People aren't going to run into the lights and cameras to break the law.
You can take a seat now, Mr. Simon. Thank you. Mr. Simon, I want to talk to you about the night of June 6, 2015.
Okay.
Were you at Scooters on that night?
Well, it's not.
Do you have any control over your place being a chase place?
No, as I said, the people that created the game designated my place as a chase place.
Now, you've mentioned you've installed lights, cameras, and you trained your employees. Why did you choose these measures for Scooters?
They seemed like they would get the job done, keep everybody safe, and that's what I could afford as a small business owner of an ice cream parlor.
No further questions, Your Honor. Mr. Simon, on cross, Attorney Sears questioned you about your employees and what you do in terms of training your employees.
Yep.
You were asked about how you train your employees. Could you do anything more to train your employees to tell customers to leave at 10 p.m.?
No, all I can do is tell them personally, tell people to leave, or to tell my employees to tell people to leave. We can't touch anybody. We can't push them off the property. That would be assault.
You were also asked about the lights on your property.
Yeah.
Were these lights working all night?
They were working up past 11 p.m. for sure.
You also were asked about the cameras. Were the cameras working that day?
They were not. We had called service people that I was talking about to come and fix them.
What was the result of that?
Well, they didn't come before the incident happened, but they ended up coming.
After the, a moment. You were also asked about this incident with the little boy falling in your parking lot.
Yeah.
After that incident happened, why did you feel the need to install the lights, for example?
Just to create, as I said just a few moments ago, to create an environment that would make it less likely that an accident might happen.
You were also asked about this rise in customers and scooters. How long did you see this influx of customers for?
It wasn't very long. So the game came out that spring, and then just a few months later, in June, is when the incident happened. Could have been more than 6-7 weeks.
Okay, so not that long. Have there been any other incidents since this one?
No.
Objection,
Not at
Your
all.
Honor.
No grounds.
I would move to strike on the grounds that this is outside the scope of the record.
Have there been no incidents other than this one?
No, that there have been no incidents after this one. Was the question.
Okay.
We have no information in this record on what has happened with scooters since June 6, 2015.
Counselor?
Your Honor, assuming we're out of the presence of the jury, I'd like to testify this witness will talk about there was no incidents that happened after this to his knowledge.
And what gives you the basis for this witness to say that?
He is the owner of Scooter's Ice Cream Parlor, and he would become aware of anything that happened on his property.
All right. Was he deposed?
He was, yes.
And did this deposition take place after the incident?
I believe so, Your Honor.
So that deposition was closer in time to now than it was to the incident?
I'm not. Yeah.
Your Honor, that is not correct.
What do you mean?
This deposition was taken on the 15th day of January 2016. That would have been only 7 months after the incident, and it has been 13 months since this deposition was taking place. So the deposition would have been given closer
Was it
to
January or July?
The deposition was given January 15th, 2016.
So based on, since January 2016, in the deposition, is there any indication that anything had happened since then? I'm sorry, from July 2015 to January 2016, from the deposition, do you have any basis to believe that another incident had occurred?
Are you asking me this? Or?
Yes, I am asking.
To my knowledge, no.
So I'll give it to you for that time period. All right?
Okay.
So to that extent, the objection's overruled.
Okay. So, Mr. Simon, to your knowledge, since the incident that we're here for today happened and the time you were deposed, did anything happen, any other incidents happen on your property?
No.
No further questions,
All
Your Honor.
right. Witness is excused. The defense may call their next witness.
Good afternoon. Can you please introduce yourself to the jury?
Good afternoon. My name is Quinn Noonan.
Why are you here today, Ms. Noonan?
I was asked to evaluate the adequacy of the security measures that the ice cream parlor had on June 6, 2015.
And why are you able to evaluate the adequacy of security measures?
Well, I have extensive experience in security measures.
And what specifically do you do right now that gives you this experience in security measures?
Currently, I work as a security specialist for Guardsman Corporation.
How long have you worked there?
I've worked there since 2010.
And what are your responsibilities as a security specialist?
Well, as a security specialist, I advise clients from across the world on the proper security measures for their businesses.
What did you do prior to working as a security specialist?
Prior to working as a security specialist, I was with the Federal Bureau of Investigation for approximately 10 years.
Did you receive any special education or training to understand security issues?
Yes. Aside from attending the FBI Training Academy at Quantico. I also received a degree from Steelton Tech, as well as a Juris Doctor degree from Steelton A&M.
You stated you were here today to give an opinion about adequate security measures. Did you review anything to help you come up with this opinion?
Yes, I did.
What specifically did you review?
I reviewed the deposition of Ms. Bobby Daly, the deposition of Ms. Christy Fulatanova, the unavailable witness. I also reviewed the deposition of Mr. Teresa Simon, as well as Ms. Bryce Summerstein's opinion, and the police report and other relevant documents.
Were those materials sufficient to help you develop an opinion for today?
Yes, they were.
Were you able to, in fact, form an opinion?
I was.
Ms. Noonan, what responsibility does a store owner have for people or customers on their property?
Well, a store has a responsibility to prevent foreseeable crimes, but a trespasser only has the responsibility for themselves.
Objection, Your Honor. Move to strike.
On grounds?
Improper opinion.
Counsel?
Your Honor, under 703, assuming outside the presence of the jury, this witness, in her capacity as a security specialist, is offering her expert opinion here today, and she is allowed to testify to the fact that the plaintiff was trespassing on Scooter's property. I anticipate that the witness will tell you that that was her opinion, and that she reviewed the materials in preparation for that opinion today.
How is a security specialist able to testify about the standard of care owed to a trespasser?
She stated that her extensive training and experience as an FBI agent. In addition, since 2010, she's been working as a security specialist. She gives advice to companies regarding security issues, and she can certainly understand when someone is not supposed to be on for instance, Scooter's property.
Well, all right, so I'm still not hearing that link. So we're not questioning her expertise in security matters, but how is somebody who is an expert in security able to testify about the standard of care owed to a trespasser?
Because a trespasser is someone that is not supposed to be on Scooter's property, for instance.
Okay.
So she is offering her expertise after reviewing all the materials, the testimony, and everything in preparation for this case, and offering her opinion based on those facts and the indication that the plaintiff was there past store hours.
So I think you're missing my question. My question is more general in basis, not the specifics of this particular witness. But how could any security expert testify about the standard of care owed to a trespasser? So we have a trespasser that you're claiming that's what the plaintiff is. How can somebody who's an expert in security be able to tell us what standard of care a business owes to a trespasser?
Again, Your Honor, she is an expert in security issues.
Uh-huh. So what security is owed to a trespasser?
That there's no, if the witness is allowed to testify, that she stated that they have a responsibility for themselves.
And how can a security expert say that? What is it about being a security expert that would allow them to say that statement?
Because she's under 703, she's allowed to review the facts and give an opinion based on the facts. And her determination that the plaintiff was trespassing, again, is based on her extensive experience in security issues and knowing when someone is supposed to be in a certain location and when someone's not supposed to be.
Is there anything else you'd like to be heard on?
Your Honor, it's the plaintiff's position that this witness can give an opinion as to what adequate security measures are. We're not contesting that this witness is an expert in security. However, it's the plaintiff's position that this witness cannot give an opinion as to the duty that's a defendant owed anyway, as that's a legal standard.
Well, I think a security expert can certainly, just as a security expert can say, this is what kind of security someone needs to have for anybody that would be in the business, properly on the business property, could also say, well, if they're not supposed to be there, then we don't owe them anything, and then they're responsible for themselves. And certainly as somebody who's an expert in security would then be able to say what kind of responsibility they would have for themselves in terms of threat assessment and whatever that might be. So to that extent, I'm going to overrule the objection.
Ms. Noonan, you stated that trespassers have a responsibility for themselves. I'd like to talk to you now about whether or not the plaintiff was trespassing on Scooter's property on June 6, 2015. Are you aware from your review of the record what time Scooter's closes?
Yes, my review of the record indicated that Scooter's closes at 10 p.m.
And what time did the attack occur on the plaintiff?
Based on my review, the attack occurred at approximately 10:45.
And again, based on your review of the record, was the plaintiff trespassing?
Objection.
Grounds?
Improper opinion.
Counselor?
Your Honor, assuming we're outside the presence of the jury, this witness has just testified to the standard of care. Again, under 703, or excuse me, under the expert can testify as to the ultimate issue in this case, and the defense is arguing that the plaintiff was in fact trespassing on June 6, 2015.
Counselor? Anything else like that?
Your Honor, it's the plaintiff's position that the plaintiff, being a criminal trespasser, is outside the area of this witness's expertise. It's something that this witness cannot opine.
Overall.
Based on your review of the record, Ms. Noonan, was the plaintiff trespassing?
She was, yes.
What facts in the record indicated that the plaintiff was trespassing?
Based on my review of the record, Ms. Daly was asked to leave the property numerous times, and despite being asked to leave, she actually stayed on the property.
Now, I'd like to talk to you about the security measures that Scooters had in place, especially on June 6, 2015. What kind of security measures would prevent foreseeable incidents?
Two of the things that could prevent foreseeable events would be cameras and lighting.
Your Honor, permission for the witness to step down and assist in a testimony using a demonstrative.
Yep.
Now, Ms. Noonan, you mentioned cameras and lighting. Can you please just point out where the cameras are on Scooter's property?
Yes, based on my review of the record, Scooters had two cameras on June 6, 2015. One was located here and one was located here.
Did they have any other cameras?
Based on my review, there were some cameras that were located inside the building, but those were the only two cameras located on the outside.
Now, you mentioned cameras as a safety measure. What are the purpose of cameras?
Well, cameras act as a deterrent. You see, if a criminal actor believes that they're being recorded, they're less likely to commit crime.
Were the cameras at Scooters on June 6, 2015 effective?
Yes, they were.
Why do you say that?
Because, based on my review of the record, the attack occurred in this location here, and the cameras pointing from this direction would be seen from this location where the attack occurred.
When you say be seen, what do you specifically mean? Let's start. Where are the cameras facing? Excuse me.
This camera is facing southwest, and this camera is facing northwest.
So in the general direction of the parking lot area?
That's correct.
And now, so you stated that in your review, the plaintiff was standing where that KF is?
Yes, that's correct.
And now, could a criminal actor see the cameras for that location?
Yes. Someone standing in this location would be able to see the cameras, this one here or this one here.
Now, Ms. Noonan, you also mentioned lighting. What is the purpose of lighting?
Similar to cameras, lighting also acts as a deterrent. Where there is a lot of lighting, people fear that they're going to be caught, and so they're, of course, less likely to commit a crime.
Can you just point out on the diagram where the lights were on Scooter's property?
The lights in the parking lot were located here, 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 here. There are 6 of them.
So now, based on these lights that you've just pointed out for us, did Scooters have adequate lighting?
Yes, they did.
Why specifically do you say that?
Well, again, because the incident occurred here, the lighting was sufficient enough to indicate, to spill over onto the sidewalk. Additionally, I reviewed a police report that suggested ambient lighting was sufficient.
And what exactly did that police report tell you about the sidewalk area?
That it was adequately lit.
Now, Ms. Noonan, you told us that Scooters now had adequate security on June 6, 2015, based on the cameras and lights that they had in place. Can a business have proper security but still have a crime take place?
Yes, of course.
Why specifically do you say that?
Well, even with implementing the most perfect security measures, crime still occurs all the time. So even if a security measure is adequate, it's not necessarily going to prevent all crime.
You may take a seat, Ms. Noonan. Ms. Noonan, I'd now like to talk to you about the plaintiff's conduct on the night of this incident. You mentioned earlier that the plaintiff was trespassing and that trespassers have a responsibility for themselves.
That's right.
Is there anything in the fact pattern that indicates the plaintiff did not have an eye out for his own safety that night?
Yes.
What specifically did you review that tells you that?
Well, based on my review of the record, when Miss Daly was attacked, she was first warned by her friends that there were individuals approaching. And it was at that point that, based on my review, Miss Daly didn't even look up from her phone in order to look to see who was coming. And so she, despite all of the security measures that were in place, she decided to ignore them.
You stated that her friends told her someone was coming. Was there anyone else that told her that she should leave the property?
Well, Miss Christy Felatonova told her to leave.
Ms. Noonan, based on your education, expertise, training and experience, as well as the review of the materials in preparation for today, do you have an opinion to a reasonable degree of professional certainty as to whether Scooter's Ice Cream Parlor had adequate security measures in place on June 6, 2015?
I have. Yes.
What is that opinion?
Objection.
What grounds?
Asked and answered. Your Honor, may be heard.
No.
What is that opinion, Ms. Noonan?
That on June 6, 2015, Scooter's Ice Cream Parlor did have adequate security measures in place.
Now, Ms. Noonan, the plaintiff was still attacked in this case. Does that factor into your opinion at all?
It does not.
Why doesn't it factor into your opinion?
Because as I've mentioned, the plaintiff was not looking out for her own safety and was in fact trespassing on the property.
May I proceed, Your Honor?
You may.
The plaintiff was asked to leave not once, not twice, but 3 times on June 6, 2015. The plaintiff chose to stay at Scooter's Ice Cream Parlor after the store closed to play this game Chase 'Em. The plaintiff chose to stare at her cell phone because she was so obsessed with playing this game that she was completely unaware of her surroundings. Today, we are asserting 2 affirmative defenses: that the plaintiff was trespassing and that the plaintiff acted negligently on June 6, 2015. The plaintiff was trespassing because she was told to leave Scooter's Ice Cream Parlor numerous times after the store closed. The plaintiff acted negligently because she was so consumed about what was going on in her cell phone that she did not know what was going on around her, and she stayed outside late at night after the business closed to play this game Chase 'Em. My co-counsel, Ms. Fornes, came up here earlier, and she discussed 3 principal points with you. The first point, that the plaintiff was asked to leave. The second point, that Scooter's Ice Cream Parlor had adequate security measures. To that third point, that the plaintiff was not paying attention the night she was attacked. Let's first discuss that first point, that the plaintiff was asked to leave Scooter's. You heard today the deposition transcript of Ms. Christy Filitanova, who was the employee working at Scooter's Ice Cream Parlor on June 6, 2015. Her deposition told you that she asked everyone to leave at 10 o'clock p.m. She specifically told the plaintiff and everyone to go into the parking lot area. And the plaintiff hung out in the parking lot area, and then Ms. Filitanova stated that she had to go outside and tell people to leave again. At that point, the plaintiff did not leave. Most customers did. The plaintiff decided to stand in the sidewalk area after again being told to leave the property. The plaintiff was trespassing on Scooter's Ice Cream Parlor on June 6, 2015 because the employee working there kept telling her to leave, and she refused to do so. Now I'd like to discuss the security, that second point, that Scooter's Ice Cream Parlor had adequate security measures in place. Today, the owner of Scooter's Ice Cream Parlor took the stand, Mr. Tracy Simon, a small business owner in the town of Steelton. Mr. Simon told you that he installed security on his property. He indicated that he had cameras inside of Scooter's, and then he had 2 cameras right outside. And the doorway was right here, so you had 2 cameras right outside the doorway. He also told you that he installed 6 lights on the parking lot area. Now, you also heard from the defense expert witness, Ms. Quinn Noonan, who told you about her extensive experience regarding security issues. She confirmed what Mr. Simon said, that he had the cameras inside and outside of Scooter's here, and additionally, he had lights on in the parking lot. Ms. Noonan told you that the security system Mr. Simon had in place was adequate and was proper for a small business such as Scooter's. She also told you that trespassers on this property have a responsibility for themselves. Ms. Noonan also explained to you today why these cameras and these lights were adequate. Now, I also went through today the police report, and you received a copy of the police report during today's trial. The plaintiff was attacked over here where this KF was. And today there has been some disputing testimony that the plaintiff may have been attacked over here. No matter where the plaintiff was attacked, this police report tells you that when officers arrived to the scene on June 6, 2015, that the parking lot was appropriately illuminated and the sidewalk outside of Scooter's had ambient light. Ms. Noonan took this into consideration in preparation for her opinion here today. And she indicated that Scooter's security was adequate. Now I'd like to focus on that last point, that the plaintiff was not paying attention. The plaintiff took the stand today, and she admitted to you that the game Chase 'Em was popular. She admitted she was playing Chase 'Em on June 6, 2015. She admitted she was playing Chase 'Em at Scooter's and when it closed. The plaintiff admitted that she was told to leave. She also admitted that she did not leave. On cross-examination of the plaintiff, she also indicated to you that her friend suggested someone was coming. The plaintiff did not leave. The plaintiff also admitted that she knew someone was coming and had stated, "I knew I'd find some of these video game nerds here." The plaintiff did not react. That's because she was staring at her cell phone, and she was not leaving Scooters until she caught that rare Chaser monster. Now, today you're going to have some questions to answer. And the first question, was the plaintiff trespassing? Yes. We told you here that today because the employee told the plaintiff to leave Scooter's property numerous times after the ice cream parlor closed. And that second question, is Scooter's responsible? No. Because the cameras and lighting and the security system Mr. Simon had in place was proper for a small business in Steelton. Now, I'd like to tell you a story to kind of give us an idea of what happened here today. There was a man in a town, and he hears a radio report that said a storm is coming and is going to flood the entire town. And he says he's not going to leave. So he says, "I'm devout, God loves me, and God will protect me." Now, of course, the storm comes into the town and floods the entire town. And the man is now on his roof because the town is flooded. And a boat comes by. And these people on the boat yell out to him and say, come over, we'll save you. We'll get you to safety. The man says, "No, I am devout. God loves me. God will protect me." He chooses to stay on his roof. A helicopter comes right above him on his roof and says, they throw down a ladder and say, "Jump on, come on, we'll take you to safety." The man says, "No, I am devout. God loves me. God will protect me." The man ultimately passes away, and in heaven he requests an audience with God. And he asks God, "Why am I here?" God says, "I gave you a radio report, a boat, and a helicopter. What the hell are you doing here?" The plaintiff was told to leave. He was warned by his friends, and he was warned by his assailant. What the hell are we doing here?